So it's a great pleasure to have here at FGV Direito SP Professor Heidi Hurd. She's Ross and Helen Workman Chair in Law and co-director of the program in Law and Philosophy at the University of Illinois. So it's a great pleasure to have you here.
Thank you.
We know that you have a very wide and open span work. We're going to try to tackle a little bit on some of the issues you have been working on. And I wanted to start with the philosophy of environmental law, which I believe is one of the main topics you have been working in the course you were giving at FGV. So what are the main questions you have been working in this more broad topic, and what drew you to this topic?
Okay. Well, let me reverse the order of those. What drew me to the topic was a sense that, and this is with apologies to all my colleagues, a sense that I was rearranging the deck chairs while the Titanic was sinking, that I was worrying about philosophical problems of an interesting sort, but not a sort that was relevant to some of the biggest issues of the day. Climate change, loss of species, water and air pollution. Our world seems to be crumbling around us, and I looked around, and I've got to say, the literature in environmental ethics is very thin, and I thought that philosophy owed more to the discussions of the big issues of the day than it had brought to those issues yet. And so I started to canvass the literature and to think about the problems that face our planet globally, and to ask what philosophy could bring to the table. And the answer ultimately is that philosophy, ethics, applied ethics, is fantastically anthropocentric. So it's, I suppose, no great surprise that if you look to philosophy for reasons for people to be more sharing with other species of the shrinking resources on the planet, you come up empty-handed all too often. So my work concerns different theories of sustainability, which theories of sustainability require a more sharing and caring ethic with regard to the planet's resources and the 10+ million other species who share the planet with us. And it asks into the moral considerability of those other entities who are increasingly getting squeezed out of the spaces that we have so powerfully invaded.
And in this research, do you believe that the main philosophical strands, utilitarianism, deontology, they are well equipped to deal with these main concerns and some of our intuitions regarding the environment, nature?
Yeah, that is exactly the question that the paper that I recently wrote asks. So utilitarianism, you would think, has resources that would require us to enlarge the category of entities whose utility or welfare counts. I mean, after all, animals are sentient beings, and inasmuch as they're sentient beings that experience pain and pleasure, they have at least simple desires. They therefore have what most utilitarians would think of as utiles. And so it's always been surprising to me that utilitarians haven't had Bentham's view that the category of moral concern extends not just to human beings, but to all sentient creatures. Now notice that wouldn't get you to the view that plants or even non-living entities have value in and of themselves, but it would certainly broaden the category of moral concern beyond human beings. Do deontologists have greater reserves? Well, Bolivia famously made history a few years ago by rolling out the claim that it was according rights to nature. And these sounded like categorical rights, appointing an ombudsman to speak for Pachamama and according nature itself rights to life and rights not to be disturbed by mega infrastructure and so forth. The question is whether that talk is just talk, right? Whether rights really can be attributed to entities other than animals and other than sentient beings, other than humans and other than sentient animals. And I think the answer is largely disappointing for people who think that you might accord rights to nature. Even if you were to accord rights to living creatures, living entities that weren't creatures, rights have lots of loopholes in them that would permit a lot of environmental destruction. So for example, it's classic for rights theorists to think that the doctrine of double effect applies, so that you can't do purposefully something in the name of good consequences, but you can do it knowingly when consequences would justify it. So, classic principle of just war theory. You can't purposefully drop a bomb on a housing development to kill 100 people as a means of bringing the war to a speedy end, because that would be to purposefully violate the rights of life of those civilians. But you can drop a bomb on a munitions plant when you know it's going to kill 100 civilians, because it's a known side consequence rather than a purposeful end. Lots of environmental destruction is merely a known side consequence. We don't set out to eradicate species. We don't set out to, pollute rivers to the point that they can't sustain life. Those are simply known side consequences of purposive actions done for other reasons. The doctrine of double effect makes an enormous amount of environmental devastation just fine on a rights-based theory. So I ultimately do think that utilitarianism and deontology come up short in their ability to provide us with the moral tools that are muscular enough to prevent environmental destruction.
And by this point, do you believe you already have framed a third
an
alternative?
Well, here's one that's tempting. It's tempting to move to virtue theory. It's tempting to move to the claim that virtuous people would live their lives as if the rights that rights theory would extend to environmental entities, if it were muscular enough to do so, in fact constrain action. So a virtuous person knows her place in the universe, is modest about her claims vis-a-vis species that have been in place for much longer than humanity ever has. She's epistemically modest. She doesn't sort of have the conqueror's view that you destroy before you learn what it is that you're destroying. So there's lots of reasons to think that virtuous people would tread lightly, much more lightly than humanity has been treading. And so you might think that we could find moral recourse in theories of what it means to live virtuously as a member of a planet that has 10+ million other species. Here's the problem with that view. It still makes the value of environmental entities all about us, because it's just all about our virtue, right? If we were all as virtuous as we could be, I still wouldn't think that our collective virtue exhausted the value of the Pacific Ocean or the value of polar bears. So it seems a mismatch still to think that we can account for all of our intuitions about the value of the environment by collapsing them into claims about human virtue. It's still just as anthropocentric as everything else.
Okay, well, quite interesting. Well, is it okay if I change topics
Sure.
a little bit? Okay. In Brazil, you're very well known for your book, Moral Combat. It was translated into Portuguese. And could you summarize the main thesis in that book?
Yeah. So moral combat is all about the question of whether morality pits us against one another in gladiatorial circumstances. And that's why it's titled what it's titled. It's all about the question of whether it could ever be right for you to do something that undoes or prevents what it's right for me to do, so that my doing what's right comes at a cost of you doing what's right, and you doing what's right comes at a cost of my doing what's right. Now notice there's nothing contradictory about that. It's not that morality is saying to me, do both P and not P, as philosophers would say, right? Do both action P and action not P. It's not that prospect. I don't think morality is plausibly contradictory in that way. But notice the tension. It could say to you, you do act P, and it could say to me, do act essentially not P, or do an act that makes it the case that not P. So that's the question raised by the book, and it comes in lots of different forms. In the legal system, it comes in the form of citizens being justified in violating the law, that is, being justified in engaging in civil disobedience, but judges being justified in condemning them for so doing. And if a judge takes it to be the case that the judge shouldn't condemn a citizen for doing what morality required the citizen to do, and therefore exonerates the citizen, is it plausible that the system designer could condemn the judge? Right? So we have layers of roles within a legal system, and the question about moral combat gets extended to the question of whether individuals within these different roles within the hierarchy of a legal system could rightly circumvent what others are right to do. And ultimately the book argues against the moral plausibility of moral combat, both in the case of two individuals and in the case of officials within a hierarchical legal system. And notice that to argue that is ultimately to argue that law itself can't counterweight morality's injunctions. If morality makes it the case that I should disobey the law, the argument is then the judge should forgive me for so doing, should exonerate me from so doing. The system designer should not, impeach the judge. But notice that's to say that abiding by the law doesn't necessarily insulate you from the judgment that all things considered you've done wrong. And that's to say that law doesn't have the ability to trump morality. And that's why I get called, an anarchist. It's why I get called sort of a natural rights theorist, because I'm prepared to say at the end of the day that there's one and only one thing that obligates people, and that's the injunctions of morality. And law, happily, is in many circumstances an effective heuristic to getting at what those injunctions are. But when it's not, it's rightly violated.
Okay. Well, that invites two questions, the way I see it. Well, the first one would be like a prompt reaction to what you have just said, which is, do you think people get it right in putting you in these, categories or boxes of a natural lawyer or an anarchist?
Well, I'm happy for those. I'm perfectly happy to be assigned to both of those positions. They're sort of funny because usually anarchists don't wear the cap of being natural law or natural rights theorists and vice versa. But there is a significant sense in which I just don't take legal institutions and the law itself to have an authority separate from moral authority, so that when the two conflict, law sometimes trumps morality. I just don't buy it, But that is to say that when I'm sitting at a stoplight at 2 in the morning and there's nothing coming from the right and nothing coming from the left, and I can see both ways, I have no problem driving through a red light, because I don't take it to have any more authority than advisory authority. And in that circumstance, it's just bad advice.
So this answer kind of relates with the second question that I had to pose you. So would you say, or not, or what kind of answer would you give to the question of why would we should engage, why should we continue to engage in law formalizing or legislating or making law as a formal enterprise?
Yeah.
And you have just given something that I believe could be a part of an answer, like law advises us. It has an advisory, are there other...
Right. Well, that would be my answer, right? Well, there's two. I mean, I guess we could tease out a couple of things. So in some circumstances, all we're seeking are salient coordination solutions, right? We're only seeking to coordinate with one another, right? I need to know whether you're going to drive on the left so I can drive on the right, or vice versa. I need to know whether you're going to stop at that cross section, or I'm going to, or we both are, because the last thing in the world we want is for both of us to plow into each other. In lots of circumstances, the law just solves coordination problems. And however it solves them is fine, because all we need is a solution. We don't need any particular solution. Any solution that's salient is all we need. It's not advising so much in that context. It's just giving us a salient coordination solution. In other circumstances, we genuinely need moral advice, or we genuinely need moral guidance, partly because we're all too busy to constantly recalculate moral matters on a daily basis given everything else we're doing in life. I'm going to sit at a red light most of the time because I just don't want to rethink the judgment that the red light is effectively embodying. And that's true across the board with law. Law gives incredibly valuable advice to busy people who have many other things to do in life than recalculate all the possible moral permutations that inform, whether to cross the street now, whether to pay taxes now, whether to design, I don't know, the windshield wipers this way or that way. So the answer is law is valuable because it gives moral advice. When it's valuable, it's because it gives moral advice, or it's solving coordination problems. And when it's not doing either of those things, morality steps in.
One further question about this specific topic, and it has to do with legal education. I take from your position that you would agree that legal practice is morally embedded. Lawyers, judges, they face not only coordination problems, but difficult moral problems in their daily work. So if that's the case, and if law's authority can trump morality's authority, do you believe that lawyers, the way they are being educated, do you believe that lawyers have been well educated? Do you think that legal education has been preparing lawyers for this morally charged work?
That's a lovely question. So in some ways, yes, and in some ways, no. If law is designed, if the highest and best purpose of law is to provide moral advice, then what we need is for lawyers to be extremely adept interpreters of it to those who don't know it as well, right? So they're part of the moral advising apparatus. And we want lawyers to be extremely well trained in the law so they can have this advisory, so they can play this advisory function. On the other hand, I think those who teach law all experience what we think of as the first year, first semester law student phenomenon, which is that students come in and they think that studying law is like studying anatomy. Namely, if they're given a difficult puzzle, if they could just find the book on the shelf in the library, they're just sure that somewhere there's a book and there'll be an answer in it, right? If they could just find the book. And they somehow think that all of the moral puzzles that they could ever face have been solved by the law, and if they can't find the relevant law easily, they still should keep looking because the answer must be somewhere. And what we all try to do is persuade law students in the opening semester or the opening year of law school to understand that their role lies in the interstices of laws and rules, that cases, especially the big momentous ones, are only arise because the law underdetermines the answer in those cases. And what they need to do is be able to muster moral arguments for why courts should come down one way as opposed to another way, on a difficult question that is not resolved by available law and available cases. So law students have to become expert moral advocates, right? They have to advocate in light of background commitments to moral values that they take the law to properly serve. And so I spend a lot of time with my students trying to persuade them that if they're going to become tort lawyers, they need to understand how to make arguments about corrective justice, or how to make arguments about how tort law could serve to advance, and protect wealth, or how to advance an argument that tort law can do distributive justice. Because the cases that are going to be the most difficult and the most important for them to argue are cases where the law just runs out and all that's left is morality.
Do you believe this conviction about legal education is shared across the board, across law schools in general?
I think that my colleagues, for example, I think law professors all understand that law underdetermines the right answer in lots of cases. So they all share the view that what lawyers need to learn to do is figure out how to fill the holes. Now, what you fill it with is, I think, a matter of some dispute. So economists will fill in the holes with what will maximize wealth, right? What will maximize utility translated into wealth. So if there's a gap in tort law, the right answer to the question is the answer that, achieves a wealth maximizing, accident minimizing consequence. If you're a social scientist and you're interested in filling holes with what will be psychologically either most helpful or what will overcome, for example, psychological cognitive biases, then they're going to teach students to solve problems by getting students to see the psychological pitfalls that could happen to citizens if the law goes one way as opposed to another one. So I think we all tend to use our own disciplinary expertise to fill in the holes that everybody understands law has. I'm just right about using moral philosophy, and my colleagues are not as right.
Okay. Well, I wanted to move to a maybe final topic. We talked a little bit before the interview, and you interestingly told me that you have been working on bankruptcy law and the philosophy of bankruptcy law. Could you give us a summary of your main ideas, the main ideas you have been developing in this arena, and also why you have been worried about these topics?
So I'll give you a little biographical story. I had two colleagues who came into my office years ago, and they said, we want you to write about the philosophy of bankruptcy law. And I thought, I don't know anything about the philosophy of bankruptcy law. Why would you think I would know anything about the philosophy of bankruptcy law? And they said, well, you've just written two articles. You wrote an article about promising and about why people don't have to keep promises. And you wrote an article about mercy. And if you put those two things together, mercy and the fact that people aren't obligated to keep promises, you got bankruptcy. And I thought, oh, okay. Well, I mean, that was stupid. That was dumb, because I agreed to write an article on the moral foundations of bankruptcy law, only to, of course, discover I didn't know anything. But I teamed up with a colleague of mine who is a wonderful bankruptcy doctrinalist. And together we've had altogether too many years of a partnership working out a theory that's not utilitarian, that's not rights-based, and that's not distributive justice-based. And those have been the camps into which all previous efforts to explain bankruptcy have fallen. I mean, you got to understand how puzzling bankruptcy is, right? So we have areas of law that protect and impose financial obligations on people. There's just contract law that enforces, say, consumer contracts. There's tort law that imposes damages for injuries done to others. There's tax law that imposes obligations to support a just government. And then down the hall, we've got bankruptcy law that says, nah, forget it, right? we're the area of law that undoes all of the other areas of law. Like, why would you have an area of law that undoes the obligations enforced by all the other areas of law? It's just bizarre. So the past explanations have all gone to, utilitarian accounts about wealth maximization and returning people to productive labor, rights-based arguments, both about creditors and debtors, distributive justice arguments. And we've found all of those to be unpersuasive, both morally and descriptively. And so I guess in light of what I said earlier, it should come as no surprise that what we've done is run a virtue account on bankruptcy. We take bankruptcy not to be about debtors or about creditors, not their rights, not their rehabilitation, not their wealth. We take bankruptcy to be about us, about you and about me, about what it means to be a citizen in a reasonably wealthy society, chock-a-block full of people with different talents and differences in the luck of the draw at birth and beyond. And so the argument is that virtuous people living in a relatively just and wealthy society should seek to forgive those who have passed along debts to them through an open credit economy. Ultimately, the person who defaults on a debt makes products and the cost of credit higher for you and higher for me. We're their creditors. And ultimately, if we have the means, we should be forgiving of them if the failure to forgive traps them in a kind of poverty that's oppressive. And so virtuous people would forgive their debtors as we all should forgive those whose indebtedness passed along higher costs to us, making us their creditors. It's an argument about personal virtue translated into institutional virtue at a national level.
That's very interesting. Well, I wanted to pose a last question, and it's of a more abstract nature, I guess. I take it to be the case, and if it's not, please correct me, that you work well in the intersection between various strands of moral theory, deontology, utilitarianism, archetype theory. So do you believe that each of those have a different appeal for different situations? Do you believe that each of them has a place or something valuable to say, depending on the situation or the moral problems we're dealing with?
Yeah, it's a wonderful question, and I do think the morality is incredibly complicated. I think the architecture of morality is extremely complicated. Utilitarians, morality's easy, up and down, right? We're just counting utiles. I think lots of decisions, if I could get up, I would draw Venn diagrams for you. Lots of decisions are properly made on the basis of what will maximize people's preferences. When to start the first day of school at a university? On what day should people pay taxes? When to have public holidays? There's lots and lots of decisions, both personally and institutionally, that are properly made just by effectively tabulating preferences and doing what the majority prefers, because there are not rights at stake. I take rights to define the parameters of legitimate utilitarian calculations. Utilitarianism ends where rights begin, right? So if somebody has a right, it trumps utility calculations, it trumps claims that the majority's welfare could be advanced if we just have to sacrifice this individual's rights. So I take rights to be trumps of utilitarian calculations. Now, judgments about virtue are just of a different sort. I ultimately spent a lot of time in a couple of articles asking whether there's any ability to collapse your theory about right action and your theory about virtuous character. And I ultimately argue no, that these are just different spheres with faint overlapping, because there are lots of very principled people who do exactly the right thing who we wouldn't think of as virtuous. think of Javert in Les Miserables, who's very attendant to his rights and other rights, and we don't think of him as a virtuous character. And then I think we think that there are lots of virtuous people who plenty of the time get rights judgments wrong. Think of the judge who gives people mercy too often and thus is failing to give people their just deserts often enough. So ultimately, judgments about virtue and judgments about the conditions of right action operate in separate spheres. We hope they don't conflict very often, so that the virtuous thing to do is, so that what it means to be a virtuous person commits you to doing wrong very often, or vice versa, right? We hope there's not significant conflict, but I think it's very hard to unpack one in terms of the other. So morality is just complicated. It's got really complicated architecture. And people who think otherwise, I think, haven't thought hard enough about it.
And for institutional, when it comes to institutions, you also believe that we should work with all of them together. So would you say there is important space that haven't been filled in for virtuous ethics in legal philosophy, or when it comes to thinking of institutions or formalizing rules?
Yeah, I do think that different parts of the law lend themselves more or less to one of these being dominant. So criminal law, for example. I don't think criminal law has any business using the long arm of the law, using the hefty sanctions that are available to the state when crimes are committed. I don't think criminal law has any business using that to make us more virtuous. I think that the task of making citizens more virtuous is decidedly not one that we would use the heft of the criminal law to achieve, for all sorts of reasons that go to a liberal theory, a political theory of the state. Right. On the other hand, here I am arguing that bankruptcy law responds best to a descriptive claim that that's what it's about, as well as to a normative argument about how that's what it justifiably should be. So I do think that different areas of law respond to different moral claims. Some of them are rights-based. I think that's largely true in criminal law. Some of them are utilitarian. I think tort law is extremely well explained by the economists in lots and lots of its facets. And other areas of law are devoted to, seem to be more amenable to claims about civic virtue.
Okay. Well, I said I was posing the last question, but here goes the last one. And it's going to be quick.
Okay.
What do you believe is the threshold of legal philosophy, or the vanguard of studies nowadays?
Oh wow! I don't know that I'm well equipped to answer that question. I know what I'd like it to be. It's very tempting to say that the vanguard is what I'd like it to be.
Okay.
And if I were to give that answer, I'd like it to continue to be a discipline that is in sync with analytic philosophy generally, right? With hard-edged thinking that is attuned to breakthroughs in metaphysics and epistemology and moral philosophy and political philosophy. But I'm not sure that that's where the future of legal philosophy is headed. It's certainly not where the future of legal theory more broadly is headed. I think legal theory has become very seduced by the empirical sciences, and people are doing, experimental philosophy, XFI as they call it. I don't have an affection for empirical work when it's substituted for tough analytic philosophy in circumstances in which I think hard thought goes a lot farther than polling people's opinions. But that just shows you I might not be at the vanguard. I'm a dinosaur already. So.
Thank you very much, Professor Heidi. It was a great pleasure to have you for this interview.
Well, thank you.